The Senate will come back to order. The Senate will come back to order. Chair recognizes the senator from the 7th for a motion. Chair recognizes the senator from the 7th for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to House Bill 516.
For what purpose does the senator from the 47th rise?
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to HB 516 as amended by the Senate.
It's the understanding of the chair that that motion takes precedent. Stand by. Mr. Secretary, will you read the caption of House Bill 516?
House Bill 516 by Representative Smith of the 133rd and others. The bill will be titled Enactment in Chapter 15 and Title 43 of the OCGA, relating to professional engineers and land surveyors so as to provide for the profession of professional structural engineer and for other purposes. Mr. President, the House offers the following amendment. Amend House Bill 516 by deleting lines 1 through the end, inserting in lieu thereof the following to amend Title 43 of the OCGA, relating to professions and businesses and for other purposes. Senate substitute to House Bill 516, the bill be titled Enactment Title 43 of the OCGA, relating to professions and businesses and for other purposes. Amendment 1 by Senator Ginn of the 47th and others offers the following amendment. Amend the amendment to House Bill 516 by deleting line 206 and inserting in lieu thereof the following alterations and for other purposes. That concludes the order.
Chair recognizes the senator from the 47th to speak to his motion.
Thank you, Mr. President. I know the hour's getting late. For me, one of the things that this bill started off pretty simple. It was pulling structural engineering away from the rest of the engineering in our community and in our state. So currently there's 47 states that do this, but for me, I'm going to tell you what the net effect is going to be for every citizen in Georgia. When you do that, it's going to drive the cost of construction and engineering work up for every person in Georgia. We talk about trying to save the people of Georgia money. This is one of those things that's going the opposite direction. What I'm asking that we do here tonight is to move this amendment forward, to put it back to the language that we passed in committee and put it back to the language that we passed out of this Senate body, to put it back over to the House so that they can then decide whether they want to move the bill forward or not. But for me, I'm going to ask you to support the amendment. It's one of those things that will greatly support the Georgia folks that are out there building and doing construction work and help the engineering community. Thank you very much. If there are no questions, I'll yield the will.
You have no questions. The senator yields the well. Would any other senators wish to speak to the measure? Chair recognizes the senator from the 7th to speak to the motion.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I appreciate the senator from the 47th, and I appreciate his passion. But at the same time, I will have to respectfully disagree. I do not think that the underlying bill will raise the cost of engineering in our state. I think the underlying bill gives us an opportunity to do what a number of states across the country have already done, and that's recognize those who have to take an increased certification to receive a structural engineering designation on their license or on their certification to be a PESE. I would ask that you vote no on his motion, and that you would vote yes on the motion that I made previously to agree as amended from the House side. And with that, Mr. President, I will yield the well.
Senator has yielded the well. Would the senator from the 47th like to speak to close debate?
Thank you, Mr. President. One of the things that I want to make sure you understand, the bill that we're voting on here today is an amendment that changes it right back to the same language that we passed out of this chamber, we passed out of committee. It's not denying the structural engineers from having their license. This language simply says that we're saving the taxpayers and the citizens of Georgia money on doing engineering work in our state. And to me, I think it's one of those fiscally responsible things to do. I don't want to see the cost of engineering work go up in our state and our citizens have to pay more for it. So thank you very much for supporting the amendment.
Senator has yielded the well. The senator from the 47th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 516 as amended by the Senate. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. For what reason does the senator from the 47th rise?
Parliamentary inquiry.
State your inquiry.
Want a green vote here save the taxpayers and citizens of Georgia money?
Each and every senator will have to make that decision. What purpose does the senator from the 7th rise?
Mr. President, is it not true that leaving the threshold at 100,000 would make it consistent with the rest of the code in other respects?
Each and every senator will have to make that decision. What purpose does the senator from the 47th rise?
Green votes are good. Said it's going to save us some money.
Is that a parliamentary inquiry?
Yes, sir.
Okay, I was making sure. On the motion that the Senate agree to the House amendment to the Senate substitute to House Bill 516 as amended by the Senate has failed. The yeas are 27, the nays are 25. It's required to have 29. Chair recognizes the senator from the 7th for motion.
Mr. President, I move the Senate agree to the House amendment to the Senate substitute to House Bill 516.
Chair recognizes the senator from the 7th to speak to that motion.
Thank you, Mr. President. I don't have much else to share other than what I shared a few minutes ago. This bill has passed the Senate. It simply designates PESEs and structural engineers. It takes the threshold from 500,000 back to 100,000, which is consistent in the code in regards to other respects with this. That was the difference between the House version and the Senate version. I would respectfully request your approval and green vote and support on this motion. Mr. President, I yield the well.
Senator has yielded the well. The chair recognizes the senator from the 47th to speak to the measure.
This is pretty simple math, ladies and gentlemen. Said all you got to do is stay with me, vote red on this request here. Said and let's save the citizens of Georgia some money. Said let's go for the good engineering work.
Senator has yielded the well. Any other senators wish to speak to the motion? The chair hears none. The senator from the 7th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 516. All those in favor, vote yea. Opposed, nay. The Secretary will unlock the machine. For what purpose does the senator from the 47th rise?
Want a red vote here be a red-blooded American thing to do and save our citizens in Georgia a lot of money?
Is that a parliamentary inquiry?
It is, sir.
Okay, thank you. On the motion, the yeas are 31, the nays are 23, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 516. For what purpose does the senator from the 47th rise?
Parliamentary inquiry.
State your inquiry.
Request reconsideration.
Senator has requested reconsideration. All right, the motion to reconsider from the senator on the 47th. The reconsideration is that the Senate move that the Senate agree to the House amendment to the Senate substitute to House Bill 516. All those in favor will vote yea. Opposed, nay. The Secretary will unlock the machine. For what purpose does the senator from the 47th rise?
I need a green vote here to
Is that a
make sure
parliamentary inquiry?
Yes, sir. Parliamentary inquiry. Can I get a green vote to save our citizens?
On the motion to reconsider, the yeas are 30, the nays are 23, and this body will reconsider the motion. Once again, the senator from the 7th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 516. All those in favor will vote yea. Opposed, nay. The Secretary will unlock the machine. The senator from the 47th has a parliamentary inquiry.
Yes, sir. We need a red vote to show the red-blooded Americans how we're going to save the taxpayers' money.
I'm
Said
certain
that's
the
an
senator
inquiry
knows
all
of what
day
he
long
speaks.
and all night. I need your help, folks.
State your inquiry.
I'll even give you a go tech, but this is a red dog, red-blooded, red dog American saying, let's go Bulldogs and get it all in the red.
The chair couldn't hear you. What did you say?
I said go tech, but
That's
let's
what
go Dogs.
That's what
get
I
it
thought
red.
you said. On the motion, the yeas are 29, the nays are 25, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 516. Chair recognizes the senator from the 23rd for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to HB 239.
Mr. Secretary, can you please read the caption?
House Bill 239 by Representatives Administration of the 104th and others. A bill will be titled and act amend Title 15 of the OCGA relating courts so as established the Georgia Business Court pursuant to the Constitution of the state and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 239. A bill will be titled and act amend Title 15 of the OCGA relating courts so as to establish the statewide business court and for other purposes. Mr. President, the House offers the following amendment. Amend the Senate Committee on Judiciary substitute to House Bill 239 by striking the language beginning on line 1 on page 1 through line 523 on page 16, inserting in lieu thereof the following to amend Title 15 of the OCGA and for other purposes. That concludes the order.
Chair recognizes the senator from the 23rd to speak to his motion.
Thank you, Mr. President, colleagues. As you know, earlier today we sent over HB 239, which had the Senate position on business courts, basically requiring two-party consent. I'm pleased to announce that the House has adopted the Senate position. They've sent it back to us with some minor amendments. I'll mention those briefly. The name of the court has changed to Georgia Statewide Business Court. The filing fee is changed to $3,000. They had been at $5,000. We were at $1,000. The location of the business court will be Atlanta and Macon, which Macon had been the location in HB 239. Now, some of the major changes involve raising the threshold for claims. This was an effort to keep out the small fry, small defendants being hauled into business court. We doubled that threshold from $250,000 to $500,000. We also limited and excluded claims against consumers and farmers and employees. So they came around to the Senate position. That was something that we had agreed to in conference. They kept the presumption of that where a case is filed is where it should stay. And then the only change in the consent procedure is that they shortened the time for objection to being in business court from 60 days to 30 days. We can live with that. Then there were 3 other riders that had been previously agreed to that are unrelated to the business court. 2 of them deal with electronic filing in part Roman numeral 4 on page 16 and part 6 on page 18. These basically are tweaks on electronic filing, and I'll be happy to answer questions on them. Part 5 was a rider dealing with payment for depositions in criminal cases. Very technical. It just takes payment away from the prosecuting attorney's counsel and leaves it with the state if a deposition is taken in a criminal case. With that, I'll be happy to answer any questions about House Bill 239, the amendment that we are now considering.
Chair recognizes the senator from the 45th for a question.
Thank you, Mr. Chairman. I appreciate you working so diligently on this. Is it still true that the consent is still in this particular?
Two-party consent is still in here, and we've held firm on that.
Would you further yield?
Yes.
Is it not true that if this does not work out, and it's going to take quite a while to set this court system up, that we'll be back here next year, and when they don't get the number of filings that they need to support the court system, that we'll probably have to change back to the one-party consent?
I do not share that opinion. I believe that there'll be confidence in the business community for utilizing this court that we're providing to them.
Chair recognizes the senator from the 19th for a question.
Thank you, Mr. President. Does the senator yield?
Yes.
Mr. Chairman, is it not true that this was a carefully crafted compromise to bring along the Senate to a position that it did actually move from?
It is carefully crafted compromise to take us from where we were at the beginning of the day.
Do you think that this compromise has enough votes now to pass the Senate?
Oh, absolutely.
Thank you.
Do you continue to yield?
I will.
Chair recognizes the senator from the 8th for a question.
Thank you, Mr. President. Will the gentleman yield?
Yes.
You mentioned Macon and Atlanta is where the courts will be located. Will all cases be heard there, our hearings?
No, actually, that's a good point. All along, the bill in its various forms has required the trial of a case to be in the local venue.
Thank you. I just want to clarify that.
You have no more questions.
I urge support for the House amendment to HB 239.
Does any other senator wish to speak for or against the motion? The chair hears none. The senator from the 23rd has moved that the Senate agree to the House amendment to the Senate substitute to HB 239. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 53, the nays are 2, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 239. Chair recognizes the senator from the 28th for a motion.
Mr. President, I ask unanimous consent that the rules be suspended to allow the Senate to consider the conference committee report on HB 324.
Will the secretary read the caption, please?
Committees of Conference report on House Bill 324 by Senator Brass of the 28th and Representative Gravely of the 67th and others. Committees of Conference on House Bill 324 recommend that both the Senate and the House of Representatives recede from their positions and that the attached Committees of Conference substitute to House Bill 324 be adopted. Committees of Conference substitute to House Bill 304, a bill be titled Enactment Chapter 12 of Title 16 of the OCGA relating to offenses against public health and morals so as to provide for the production, manufacturing, and dispensing of low THC oil in the state and for other purposes. Mr. President, that concludes the order.
The senator from the 28th has asked for unanimous consent that the rules be suspended to allow the Senate to consider a conference committee report on House Bill 324. Is there objection? The chair hears none. Chair recognizes the senator from the 28th for a motion.
Mr. President, I move that the Senate adopt the conference committee report on HB 324.
Chair recognizes the senator from the 28th to speak to his motion. For what purpose does the senator from the 27th rise?
Mr. President, I ask unanimous consent to be excused from voting on HB 324 pursuant to Senate Rule 5-1.8D.
The senator from the 27th is asked to be excused from the vote on House Bill 324. Is there objection? The chair hears none and you are excused. Chair recognizes the senator from the 28th.
Thank you, Mr. President. Bringing you HB 324, the conference report. Before I get into the bill, I want to thank the governor, lieutenant governor, and the speaker for their leadership on bringing the conferees in and coming to what most of us agreed on. I went over the bill, the Senate changes, whenever that was, a couple days ago, and so now let's go over some changes here that you're going to see. So first off, first thing we did was, if you'll go to line 176 and look at product. Again, we've tightened up the language on product, and we're making it very clear that no food products can be infused with this THC oil, and we're again making it very clear that cookies, candies, edibles will not be allowed. This is strictly for oil, tincture, transdermal patch, lotion, or capsule. Next thing we've done, this is another major change. With DPH, we have actually taken the commission and removed that from DPH, and we have moved that over to the Secretary of State's office. We've done that because they don't receive any federal funding, and we didn't want to put any of that at risk. If you'll move on to the actual, and I'm sorry, I'm still kind of fumbling through this thing, but to the commission, we're keeping the university system as a part of this. We're granting them the right to produce the oil through the license that they will get issued through the commission. Gives them the ability to grow, also to produce, and then also gives them the ability to purchase from other states any legal way they can, if that's allowed. We don't know if that's going to work or not, but again, if it does, it's the best short-term solution to get medicine in these patients' hands. Now the commission, we're little changed there on what we're doing there. They're still going to be able to purchase from other states just like the university system can. We're actually giving them a little bit more leeway on, they will come up with the dispensaries, the number, and all that, but we want the pharmacies to basically have the first shot at this. And if we figure out that the pharmacies are not sufficient in getting the oil to the patients, then the commission can come in and set up a system of dispensaries. So the commission will actually determine the number of dispensaries and then all the rules and regs that go around that. The other thing we've done with the commission, if you'll remember, the House version had, I believe, 9 members or 10 members on that commission, 4 by the governor, 3 by the speaker, 3 by the LG. We have taken, the Senate version took it down to 3-1-1. What we've done is actually gone back to 3-2-2. This was kind of a compromise and didn't put too much on the governor and gave the legislature a little bit more footing there. The biggest change is if you'll go into, if you'll look at lines 368, this is where we set up the classes and the number of licenses under each class. If you'll remember, in the Senate version, we were doing 450,000 square foot cap on a Class 1 license, and we were issuing 1 license. We were doing a 40,000 cap on the Class 2 license, giving us a total of 490,000 square feet, but only 2 licenses. Essentially, we were creating a monopoly in each class. So what we've done is we have actually dropped the square footage. We are actually limiting production more than we were so in the Senate version, because we have now gone to 2 Class 1s, which we are capping at 100,000 square foot each. And then we are doing 4 Class 2 licenses, which we are capping at 50,000 square feet each. So again, this gives us a total of 400,000 square feet, which we have dropped that total of production of cultivation space that they're allowed to grow. We've dropped that from 490 to 400, but we've eliminated the ability of a monopoly by creating 2 Class 1 licenses and 4 Class 2 licenses. Some of the fees kind of changed. We had some questions on number one. We didn't want there to be a secondary market on these licenses, so we've made it very clear that there's no selling of a license. And then, so we had some concerns that really the market now becomes the selling of the company or selling off the shares. So what we did was we actually took language from the Lottery Corporation, and now if there's a transfer of that license, the initial transfer is they will pay a fee that is directly associated with the renewal fee. So Class 2 is going to pay a $100,000 transfer fee for their first transfer of ownership. The next one, that fee goes from 100 to 150, and that transfer fee each time it's done will increase $50,000. Again, we're trying to discourage, and you can't even do it for 5 years. There's no transfer licenses for 5 years. Again, the biggest thing, and this is going to constantly get overlooked, but in HB 65 that set up the study committee, any new diagnoses that comes to this legislature will have to come by recommendation of the Composite Medical Board. What we have done to tie that up even more is now the Medical Composite Board, in consultation with DPH, will now make those recommendations on a yearly basis, if there are any. So again, those of us that are concerned about this potentially leading to recreation, the biggest thing that happened in these other states, with the exception of them allowing smoking, which we are not allowing, we're not allowing vaping, the biggest thing that they did was the listed diagnoses got out of control. And what we have done is we have gotten a tight grip around that, and we will keep that tight grip to prevent us leading down to recreation. I think at this time I'll just yield for questions.
Thank you, Senator. The chair recognizes the senator from the 17th for a question.
Thank you, Mr. President. The senator yield.
Yield for the senator from the 17th.
Senator, isn't it true that you've drafted a compromise bill working with our lieutenant governor, the speaker, and the governor to make sure we're getting oil to those that need it, while also having safeguards put in place to prevent abuse, but as you said, also making certain we have other growers involved to keep from creating a monopoly?
That is exactly correct. What we wanted was, number one, was put the patient first. We have to figure out a way how we're going to get medicine in these patients' hands, which currently they don't have a legal way to do that. That was goal number one. Number two was we did not want supply driving demand. We did not want big business driving this train, and those were kind of the safeguards we put in.
Do you further yield?
I yield.
Isn't it true, Senator, that not only do I appreciate the work you've done, but the governor appreciates the work you've done on this bill as well and looks forward to hopefully getting to sign this legislation?
I hope the senator knows of which he speaks.
Thank you.
Chair recognizes the senator from the 23rd for a question.
Thank you, Mr. President. Will the senator yield?
I yield.
Why is the Medical College of Georgia in Augusta not a designated university?
We put our 2 land-grant universities, so University of Georgia and Fort Valley State are 2 land-grant universities, and we just thought they'd have the best chance at being able to get approved to do what we need them to do.
Well, Speaker, further yield.
Are you?
Medical College of Georgia has experience in testing marijuana. Wouldn't it be a logical choice?
It could be, and that option could still be on the table. I mean, we just didn't hear from them, to be honest with you.
Will the suppliers of the medical marijuana be for-profit entities?
So this is a three-pronged approach. It's got the university system with the ability to grow and produce. Anything they produce will go to the commission. The commission has the ability, and the universities have the ability, to attempt to purchase from other states. That's the second prong. The third prong is the private sector, and that is where we've issued
Would the private sector be profit or non-profit?
They will more than likely be for profit.
Is low THC still defined as 5% content?
In Georgia law, it is, yes.
There's been no correction or change on that?
Not in this bill. We did not address that.
Thank you.
Chair recognizes the senator from the 45th for a question.
Thank you. Will the senator yield?
I sure do, for the
Is
gentle
it
lady.
not true, following up on the chairman of judiciary, that Georgia is the highest percent at 5% in the nation? Is that not true?
We are one of the ones at 5%. That is accurate.
Would you further yield?
I yield.
In referencing line 692 to 697, you're talking about no licensee shall contract for services, and you mentioned state employees, their immediate family, statewide public official, or employee of a designated university, or any legislator. I was wondering if it included former legislators and former state employees, or are those only currently serving?
That would be current.
Only current.
As it reads, it is any state employee or member of a state employee's immediate family. So that would be current. As we know, we're a part-time legislature, and when we leave here, in fact, when we leave here tonight or in the morning, we go back to whatever it is we do. But when we hang it up, when we retire, you're free to go do whatever you want. We have many limitations as a legislator or as a state employee, but when you hand that over, when you give up your public service, you're free to do whatever you want in this country.
Would you further yield?
I yield.
Can the licensees receive political or give political donations to
They can,
legislators and statewide office holders?
They can. They have to disclose it, and if they're a licensee, they will have to disclose that they are a licensee.
And they have to adhere to the usual amounts that everyone else has to?
That would be correct.
But their company employees could also contribute, is that not true? At those maximum amounts?
That would be accurate. Just like any other company in Georgia.
Would you further yield?
I yield.
I don't quite understand about the commission and the retail. Is there unlimited retail that can be done, or is there a number of retail locations?
So under the guidance of the governor, he had some hesitations about the dispensaries and allowing the dispensaries. So what we wanted to do was, number one, let's let the pharmacies have the first crack at it. And if we feel like that's going to be enough to dispense the medicine to the patients, then then it can stop there. But we are giving the commission the ability to form the rules and regs and the number around those dispensaries. And with leadership being involved with this and everyone having being very hesitant on the dispensaries, and they are the ones that actually make those appointments to that commission, that's probably the safest we're going to get.
And would you further yield?
I yield.
Is it not true that the General Assembly could come back and limit that retail operation and the infrastructure?
That is exactly correct.
And would you further yield for the last question?
Sure.
Could you tell me if the Sheriff's Association, I know I've gotten letters from the Sheriff Association, are they now agreeable to this compromise, or have you heard from them?
I haven't heard from them since my last meeting with the Sheriff's Association, which was immediately when I left Ledge Council with the final instructions. I sat down with the Sheriff's Association director, walked him through what was new in the bill. I think he liked the part where we were reducing production from 490,000 square feet down to 400, but they did not like the fact that we were increasing the licenses.
Does the senator continue to yield?
For respect of all the other bills out there, I'm going to yield the well, and let me know.
Senator has yielded the well. Chair recognizes the senator from the 41st to speak to the measure.
Mr. President, very quickly, I want to say that I want to thank the senators who've worked on this, from my caucus senator from the 26 who's followed it. It's not everything everybody would want. But if you've seen in the hallways the children suffering from traumatic brain seizures and other issues, we're doing the right thing in passing this bill. I appreciate the author for bringing it forward, and I yield the will.
Chair recognizes the senator from the 46th to speak to the measure.
Thank you, Mr. President. Ladies and gentlemen of the Senate, it is not often that you will see bills presented that pass this body and came out of the committee, our Regulated Industries Committee, and that chairman be on the conference committee, but their name not be on the front of the conference report. The reason for that is that this is not the bill that passed the Senate. We had a very carefully crafted bill that was designed to get the oil to these children or other patients that needed it, but limit it only for those medical uses and not create a brand new industry of marijuana production. And that's what this bill does. So you'll kind of get the backdrop here. There are federal laws in place that prohibit the possession, the growing, the transporting, the sale of marijuana. It is a Schedule I drug, and that means it's been determined by the FDA that it has no medicinal value, and it is not studied, no clinical trials doing. There is no science behind these oil-based medications. We know they have THC in them, and we know anecdotally quite a few patients receive relief from ingesting that THC. When we first went down this path, I think it was 2015, maybe 14, we were using these CBD oils. They specifically referenced cannabidiol oils that did not contain THC or very trace amounts. That has quickly morphed into what now is admittedly oils that contain THC, just low amounts, 5% or less. The testimony in our committee was irrefutable that you can get high taking this medication. In fact, they've had people overdose by taking too much. And the crazy thing about this is none of these products, just one that is a low, like 0.3% of THC product, have been approved by the FDA. That is ordinarily not a state function for us to determine what drugs are safe, what amount of doses there should be, and doctors are not allowed to prescribe medications that are not approved by the FDA. Everything we're doing in this bill, these low THC oils, are non-prescription FDA-approved products. Non-tested, no clinical trials, and they are in violation of federal law. And that's a really sort of bizarre thing for a state to say, we're going to make it legal in Georgia, despite the fact that there are federal laws that make it illegal. Those laws remain in place, and it's just whether or not the federal government is going to enforce them. Recently, they have not. The Senate version was very carefully crafted. It allowed the state to obtain the oil for these patients from other states where it's legal. States are not subject to federal criminal laws. We could legally do that and get the oil to these patients, and the bill does call for that. That was the Senate's approach to let's get some immediate relief to these people that are willing to take a non-FDA approved oil. Secondly, we went with an approach to let our universities be able to engage in the research, production, and manufacture of these products. There is an exception under federal law that allows universities to do that if you apply for a permit from NIDA, the National Institute of Drug Addiction. And if you follow the DEA rules and regulations and the FDA rules and regulations and NIDA rules and regulations, you can get a permit to be allowed to engage in these growing, manufacturing, testing, researching of these products. We felt like that was the best way to get this oil to the children and other patients in this state that need it in a safe way, and that we could test it, and to the extent that we can in the state, make sure it's all right and wouldn't harm these people. We were not, the bill that you all voted for and passed, we're not going to allow the commercial production of these products. We were going to let this occur only if the universities decided not to pursue the licensing. And we had limited it to just 2 licenses. This version allows, in addition to the universities, 6 commercial licenses, and allows the universities to partner with 2 more corporations. So you're looking at 8 commercial entities. We are creating a new industry for a product that is not FDA approved, and we are way ahead of the science on this. I don't think that's prudent for the citizens of this state, and I think many people recognize this for what it is. This is the first step towards the commercialization of recreational marijuana. So each of you need to realize the barn door you are opening wide open here. And why is that true? Because there aren't but 8,400 Georgians that are on the registry that have been diagnosed with conditions that medical doctors in our legislation says might be helped by these medications. So why do you need 400,000 square feet of greenhouse space to be growing this, 8 different commercial producers to take care of those 8,400 people? You don't. This is how you begin an industry, and the next step is you ask to increase the square feet that you want to be able to produce it from. You ask to increase the conditions that you want to be able to treat, and then eventually you say, let's just make this legal recreationally. It would be the easiest way to handle this for everybody. That's what's going to happen, and you can look back and it'll be no fun for me to say I told you so at the time, but this is the step where you open the floodgates and you are creating the infrastructure for that industry. That's what this bill does, and that's why I'm against it. That's why you were against it at the Senate. That's why we studied this for almost 2 months in regulated industries and came up with this very narrow exception to provide the oils to the patients that need them in the most limited fashion and the safest and a legal fashion. If anybody in here says that the Sheriff's Department supports this, that is false. Most of you have gotten letters. Here's a letter on our desk. The sheriffs oppose this. When they oppose it because they know this is opening the doors to legalized recreational marijuana. Is that where we want our state to go? I don't think that's where we want to go. There are also, I think, some potential other glitches in this bill. We don't specifically allow these universities to grow the marijuana. We say they can produce and manufacture the oils, but it doesn't specify that they're allowed to even grow it. This is a situation that you've heard argued, well, we're limiting the square feet from 490,000 square feet to 400,000 square feet. 10 acres, basically, under greenhouses throughout the state. 6 different companies doing that in 2 universities. That is creating a supply that far exceeds any current demand for this product. And the reason for that is this new industry that manufactures marijuana that we're creating is anticipating and driving future demand to meet the supply we're giving them. I don't think they're going to meet that demand through additional medical needs. They're going to meet it through recreational desire, and it is a very lucrative business. So I ask you to think twice before you take this step and go from 2 universities producing it to 2 universities and 6 commercial producers at this point, and I encourage you to vote no on this conference report. Mr. President, I'm happy to take any questions, or we'll yield the well.
For what purpose does the senator from the 30th rise? Oh.
Mr. President.
One moment. Chair recognizes the senator from the 45th for a question.
Senator Yield.
I yield.
Senator, is it not true that we appreciate you as chairman and former chairman working on this issue in the Senate, and that we have worked diligently for probably the last 4 years on this particular issue? Is that not true?
Well, I felt that way until the conferees abandoned the Senate position so rapidly to go to this wide open plan, but I do appreciate the work that you've done on this issue in the past as well, and this is just totally contrary to any position the Senate has taken in the past.
Would the senator further yield?
I'll yield.
Senator, when I read the bill, I understood that those university systems could also do research and grow the marijuana to do the research on it. Is that not true?
Well, they can certainly do the research, and that's what we need. I mean, that's one of the advantages. I would expect that, first of all, they can do it legally with the license, but second, they should receive much federal funding to do the desired research that we need before we start making this widely available to our citizens.
Would you further yield?
I'll be happy to.
Senator, do you not agree in the infrastructure that is promoted in this particular bill that it's better to have a controlled setting so that you know that these 8,000 or so patients are being delivered the substance that is free of pesticide, that is actually calculated, that it's much more controlled versus buying it from another state like Colorado that might not be as heavily regulated, or purchasing it from China and getting it in the mail from China? Wouldn't it serve the consumer better in the state of Georgia to know that it's coming from a highly regulated system? Is that not true?
That is true, and the university involvement in this does allow that. It does.
You have no more questions.
The last comment would be that the minority party is supporting this. This is the first bill that we've had that has minority set-asides in it. That it calls for 20% participation by minorities in the case. And we don't complain about that, but we've never had built-in quotas in our legislation since I've been here, and I think that's a consideration we need to think about as we go forward, because we're setting precedents by doing that as well. Mr. President, I yield the well.
Senator has yielded the well. The chair recognizes the majority leader.
Thank you, Mr. President. I understand that the hour is getting late and we have a lot more important bills in addition to this one out there. So with that in mind, I call the previous question.
The majority leader has moved for the previous question. All those in favor of the motion vote yea. Opposed, nay. The secretary will unlock the machine. On the motion, the yeas are 33, the nays are 20, and this body has moved for the previous question. Senator from the 28th has moved that the Senate adopt the Conference Committee report on HB 324. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. On the motion, the yeas are 34, the nays are 20, and the Senate has adopted the Conference Committee report on HB 324. Chair would like to thank the conferees, Governor Kemp, Speaker Ralston, and my entire policy team for a common sense compromise on HB 324. Thank you very much. Chair would like to recognize the senator from the 20th for a motion.
Mr. President, I move that the Senate agree to the House amendment to the Senate substitute to House Bill 373.
Mr. Secretary, will you please read the caption?
House Bill 373 by Representatives Workheiser of the 157th and others. The bill will be titled Enactment Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to the Department of Labor and Employment Security and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 373. A bill will be titled Enactment Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to the Department of Labor and Employment Security and for other purposes. Mr. President, the House offers the following amendment. Amend the Senate substitute to House Bill 373 by deleting the lines 18 and 19 and for other purposes. That concludes the order.
Chair recognizes the senator from the 20th to speak to his motion.
House Bill 373 is to allow the Georgia Department of Labor to fingerprint their employees so they can have access to financial records through the IRS. And seems to be a lot of back and forth as to where they want the Workforce Development Commission to be. It's been in about 4 or 5 different places in the last 4 or 5 years. But anyway, this would, the amendment simply keeps it with the Department of Labor. Keeps it with the Technical College System of Georgia instead of moving it somewhere else. I'd ask for your favorable consideration. Thank you.
Senator has yielded the well. Does any other senator wish to speak for or against the motion? The chair hears none. The senator from the 20th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 373. All those in favor will vote yea, opposed nay. The Secretary will unlock the machine. On the motion, the yeas are 52, the nays are 0, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 373. I'd like to take a moment of personal privilege and introduce or welcome back to the chamber some important people to me that the kids have been here a couple times, but my wife, Brooke, has not been here since the day we came in. We got Ryder. Most of y'all know Ryder. Parker and Baylor, and obviously my wife, Brooke. We want to thank y'all for treating us so great this year. It's just been an amazing experience for us getting to know everybody and being a part of this family here in the Senate. And I want to personally thank each and every one of you for welcoming us into this body and allowing us to be a part of what we're doing here. We're excited about the days in front of us here in Georgia, and we want to thank each and every one of y'all for being a part of that team. Thank you. Ready? Hit it one time. Stand up there. Stand up there one time. One time. He's going to stop asking me at home to do that now. Chair recognizes the senator from the 7th for a motion.
Mr. President, I move that the Senate suspend the rules to take up and adopt the conference committee report on Senate Bill 72.
Will the secretary read the caption?
Senate Bill Committees of Conference report to Senate Bill 72. The Committees of Conference on Senate Bill 72 recommend that both the Senate and the House of Representatives recede from their positions and that the attached Committees of Conference substitute to Senate Bill 72 be adopted. Committees of Conference substitute to Senate Bill 72, a bill to be titled and act to amend Chapter 1 of Title 27 of the OCGA relating to general provisions relative to game and fish so as to remove a prohibition on hunting on wildlife management areas, change the date of effective rules and regulations of the Board of Natural Resources, and for other purposes. That concludes the order.
Senator from the 7th has asked for unanimous consent for the rules to be suspended to allow the Senate to consider the conference committee report on Senate Bill 72. Is there objection? The chair hears none. Chair recognizes the senator from the 7th.
Mr. President, I move that the Senate adopt the conference committee report on Senate Bill 72.
Senator from the 7th has moved that the Senate adopt the conference committee report on Senate Bill 72. The chair recognizes the senator from the 7th to speak to his motion.
Thank you, Mr. President. Ladies and gentlemen, the Senate. Senate Bill 72, if you remember, is the conglomerate DNR hunting bill, omnibus hunting bill, as I would call it. The only changes from the as passed the Senate version and the version that is laying on your desk in the conference committee report are the changes found on line 64 to 67. That takes out of the code in regards to having a plug in your shotgun, and the only animal that you had to have a plug in your shotgun for under DNR code was squirrels. So it takes that out. It also takes silencers and suppressors back to the way they are under current law. And the effective date on air guns goes from July 1 of 2024. We've taken that back to July 1 of 2020 to give us an opportunity next session to look at this one more time. The only other thing that it does is it codifies in code the DNR board rule change in regards to hunting over supplemental feed. If there are no questions, Mr. President, I will yield the will and ask your favorable consideration.
I don't know what you said, but everyone seems to be tearing a bill up right now. Is that your bill?
I'm good.
Chair recognizes the minority leader for a question.
Senator, is it not true that this is primarily a department bill? There is an issue, though, about hunting over bait that slightly changes the parameters that presently exist. So if somebody is sensitive to that issue, they should be aware of it.
Understood, and I respect the minority leader's position, and we've had discussions offline about that, and I believe that's in regards to the 50-foot on private property issues. That was in the version as passed the Senate. And I would respectfully ask your favorable consideration of the conference committee report that's before you. Mr. President, I yield the will.
The senator has yielded the well. Any other senators wish to speak for or against the measure? The motion. Chair hears none. The senator from the 7th has moved that the Senate adopt the conference committee report on Senate Bill 72. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the motion, the yeas are 48, the nays are 5, and the Senate has adopted the conference committee report on Senate Bill 72. Chair recognizes the senator from the 56th for motion.
Mr. President, I move the Senate agree to the House amendment to the Senate substitute to House Bill 224.
Mr. Secretary, please read the caption.
House Bill 224 by Representative Williamson of the 115th and others. The bill will be titled Enactment Article 2 of Chapter 7, Title 48 of the OCGA, relating an imposition rate computation exemption from state income tax and for other purposes. Mr. President, the Senate offers the following substitute to House Bill 224. The bill will be titled Enactment Article 2 of Chapter 7, Title 48 of the OCGA, relating to the imposition rate computation exemption from state income tax for other purposes. Mr. President, the House offers the following amendment. Amend the Senate substitute to House Bill 224 by deleting, by adding a new paragraph to subsection E, by adding new subsection, and for other purposes. That concludes the order.
We still have business to conduct here in the Senate. I'd ask that we give our undivided attention to the senator from the 56th.
Thank you, Mr. President. This is the same bill that we had passed previously. The House made a couple of minor amendments, which we agree with, which was to take the 5-year sunset off because it still has 2 years left. It still includes the quality job tax credits, and the bill is ready to go in order to help out those folks in historic tax credits in rural Georgia. If there are no questions, I'll yield the well.
Chair recognizes the senator from the 45th for a question.
Will the senator yield?
I yield.
Senator, is it not true that unfortunately those tax credits get used up very quickly, and it's oftentimes the big corporations that receive those tax credits? Is it not true?
It is true that they are used by large corporations and small individuals, but I know large corporations do a lot of that work.
Would you further yield?
I yield.
Do you think in the future it would be prudent to possibly have caps on it and also to segregate so that small entrepreneurs like brew pub owners, individuals had the same opportunity to be accessible to those tax credits? Is that not true?
Absolutely, Senator. I'd love to work with you on that. If there are no more questions, I'll yield the well, Mr. President.
You have additional questions. Do you continue to yield?
I yield the well.
He yields the well. Senator from the 56th has moved that the Senate agree to the House amendment to the Senate substitute to House Bill 224. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. On the motion, the yeas are 49, the nays are 3, and the Senate has agreed to the House amendment to the Senate substitute to House Bill 224. I would like to take a moment to thank some very, very important help we've had all day today. These kids have stuck around all day with us. The pages that are still here with us today, would you all come forward, please? Aaron Ely, Karen Kinsley, Macy McGinnis, Sabrina Mejia, Rehan Soni, Sean Alexander, Bethany, Samuel Beauchamp, Christian Dent, Braylon Henderson, Taylor Henderson, Bailey Hicks, Mary Ellen Holtz, Holly Hudson, Grace McDaniel, Garrison McDaniel, Ansley Patterson, Gracie Patterson, Ariana Shaw, Trevis Smith Battle, Rahan Soni, Halen Ward. And we have one extra special guest with us today. Trinity Seals is celebrating a birthday. Thank you all so much for joining us today, and don't tell anybody how late you stayed up tonight. Thank you all very much. Chair recognizes the senator from the 9th for a motion.
Mr. President, I ask unanimous consent that the rules be suspended to allow the Senate to consider the conference committee report on SB 214.
Senator from the 9th has asked for the unanimous consent for the rules to be suspended for a conference committee report on Senate Bill 214 to be considered. Mr. Secretary, will you read the caption?
Committees of Conference report on Senate Bill 214. The Committees of Conference on Senate Bill 214 recommend that both the Senate and the House of Representatives recede from their positions that the attached Committees of Conference substitute to Senate Bill 214 be adopted. Committees of Conference substitute to Senate Bill 214, a bill be titled enactment various titles of the OCGA so as to change and provide for regulations governing certain professions to prohibit professional licensing boards from refusing to issue a license or suspending or revoking the license of a person who is a borrower in default under an educational loan issued through the Georgia Higher Education Assistance Corporation for other purposes. That concludes the order.
Senator from the 9th has asked for unanimous consent that the rules be suspended to allow the Senate to consider a conference committee report on Senate Bill 214. Is there objection? The chair hears none. Chair recognizes the senator from the 9th to speak to Senate Bill 214.
Well, Mr. President, first I would like to move that the Senate adopt the conference committee report on SB 214.
Let me get my next card. Senator from the 9th has moved that the Senate adopt the conference committee report on Senate Bill 214. Chair recognizes the senator from the 9th to speak to the motion. I should have known that.
Thank you, Mr. President. I'm glad to bring back Senate Bill 214 in a new format. We'll go over it fairly quickly. Section 1 is verbatim SB 92 that we passed not unanimously, but overwhelmingly out of the Senate earlier in the session, which would prevent an occupational license for many professions from being suspended due to non-payment of their student loans. Section 2, this deals with the tattoo code that I went over very detailed with the senator from the 45th, dealing with microblading and adding some better language that would allow for better, add teeth to the if there's a complaint made. Section 3.1 allows those who've made mistakes and served their sentences to make sure they can pursue careers in cosmetology, barbers, nail techs, etc. We discussed that earlier. Section 3.2 is Secretary of State recommendation that requires apprentices in those same sections to take their theory test within the first 12 months. Section 4.1 deals with electrical contractors. Actually, Section 4 deals with electrical contractors. The first allows for the division of electrical contractors, gives them more options for allowing continuing education. And Section 4.2 would prevent an a contractor from advertising as a licensed electrical contractor unless they are indeed licensed, or if their work will be performed by a licensed electrical contractor. If there are no questions, I'll yield the well.
You have a question.
I'll yield for one question.
Chair recognizes the senator from the 48th for a question.
Thank you, Mr. President. Does the chairman yield?
I will.
Could you please tell me why all these added provisions, for example, lines 609 to 613, that's just an example, it's throughout the bill here, why these are necessary?
609, 613?
Well, I use that as an example.
Well, so what I would say is that these are provisions that made it out of committee. Every one of these provisions were vetted by at least one committee. They just didn't quite make it over the line. Talking about 609 to 613, we need to make sure that people who are advertising as electrical contractors actually have their license, so that they are not falsely advertising to people, doing bad work, and creating safety issues. And it goes so forth and so on.
Okay. Thank you.
The
I yield the well.
Senator yields the well. The chair recognizes the senator from the 53rd. For what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
This is a cosmetology bill, correct? No, is it not? Okay. I'd like to point out his cosmetologist has given him a new haircut.
Thank you for that insight. It's been a long time since the reading of the journal this morning and those pearls of wisdom. All right, does any other senator wish to speak for or against the motion? Chair hears none. Senator from the 9th has moved that the Senate adopt the conference committee report on Senate Bill 214. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. For what purpose does the senator from the 19th rise?
Parliamentary
State your inquiry.
Is it not true that we're rounding third and headed towards home, Mr. President?
I'm a pitcher. We got 2 strikes, 2 outs, and I got a breaking ball in my hand. Chair recognizes the senator from the 17th.
Parliamentary inquiry.
State your inquiry.
Isn't it true it's time to bring in the closer?
The closer's already in the game. On the motion, the yeas are 42, the nays are 8, and the Senate has adopted the conference committee report on Senate Bill 214. Chair recognizes the senator from the 56th for a motion.
The great closer, Mr. President, I move that the Senate agree to the House substitute of Senate Bill 15.
Mr. Secretary, please read the caption.
Senate Bill 15 by Senators Albers, the 56, and others. The bill be titled enactment Article 27, Chapter 2, Title 20 of the OCA, relating to loitering at or disrupting schools and for other purposes. Mr. President, the House substitute Senate Bill 15, a bill be titled enactment Article 27, Chapter 2, Title 20 of the OCA, related to loitering or disrupting schools and for other purposes. That concludes the order.
Chair recognizes the senator from the 56th to speak to his motion.
Thank you, Mr. President. I'm so proud of the great work that is done by the governor, lieutenant governor, the House, and the Senate. This is Senate Bill 15, which we passed overwhelmingly. The House did make some nice little additions to this, including some concerns from the minority party of adding reasonable suspicion of violent crime to alleviate some concerns, as well as we're going to have good signage to make sure the See Something, Send Something app is up. And this is going to be a great way for us to go home and know that we kept Georgia kids safe in school. If there are no questions, I'll yield the well.
You have a question. The chair recognizes the senator from the 48th.
Thank you, Mr. President. Does the chairman yield?
Yield very quickly.
I think that this, my understanding of the wording as I am reading it very quickly is that we're not just limiting this to school areas, it's beyond school areas. Isn't that true?
This has always been encompassing all school areas and transportation to include the ball fields and everything around the school property and the transportation such as buses. That has not changed.
Okay, so it is just to the schools,
And the transportation, correct, yes.
the school buses.
Yes, correct.
Okay, thank you.
All right, I yield the will, Mr. President.
Senator has yielded the well. Any other senators wish to speak for or against the motion? The chair hears none. The senator from the 56th has moved that the Senate agree to the House substitute to Senate Bill 15. All those in favor vote yea, opposed nay. The secretary will unlock the machine. On the motion, the yeas are 42, the nays are 11, and the Senate has agreed to the House substitute to Senate Bill 15. All right, we're going to stand at ease for a few minutes and let our good friends over on the other side of the building catch up with us. Stand at ease for just a couple of minutes. Nobody go far. Not yet. Not yet. For what purpose does the senator from the 17th rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true, Mr. President, nobody wants to go into extra innings tonight?
The chair is recognizing a theme. All right, the Senate will come back to order. Senate will come back to order. We still have important business to finish. Chair would like to recognize the senator from the 44th for a motion.
Thank you, Mr. President. I move that the Senate agree to House substitute to Senate Bill 103.
Mr. Secretary, can you please read the caption to Senate Bill 103?
Senate Bill 103 by Senators Davenport of the 44th and others, a bill be titled Enactment Article 2 of Chapter 3 of Title 6 of the OCGA, relating the powers of local governments as to air facilities, so to provide that airports owned, controlled, or operated by a county, municipality, or other political subdivision of the state shall not assess any fee to a veteran for motor vehicle access and for other purposes. Mr. President, the House offers the following substitute. Senate Bill 103, a bill be titled Enactment Article 2, Chapter 3, Title 6 of the OCGA, relating the powers of local government as to air facilities and for other purposes. That concludes the order.
Chair would like to recognize the senator from the 44th to speak to her motion.
Thank you very much, Mr. President. This is a bill to basically provide 2 priority parking spaces for our veterans. This is no small airports, it's just commercial airports, and we're only talking about 2 spaces. This is simply a bill to show our appreciation to our veterans, those who have been in harm's way while we enjoy the freedoms here. Thank you very much, and I yield the well.
The senator has yielded the well. Does any other senator wish to speak for or against the measure? Chair recognizes the senator from the 31st to speak to the motion.
Thank you, Mr. President, members of the Senate. While I know that we all want to do all that we can to honor our veterans, there's a serious problem with this bill, and that is this affects airports all across our state. And many of our airports are very small rural airports, and they don't have a whole lot of parking spaces. And when you designate 2 parking spaces for veterans, then it will put it'll cause a problem in some of these airports. So I would urge you to vote no here, and let's see if we can get a bill that will accommodate our veterans without taking the parking spaces for our airports. Mr. President, I will yield the well.
Senator has yielded the well. The senator from the 44th has moved that the Senate agree to the House substitute to Senate Bill 103. All those in favor vote yea, opposed nay. The Secretary will unlock the machine. For what purpose does the senator from the 44th rise?
Mr. President, parliamentary inquiry.
State your inquiry.
Is it not true that this bill does not affect any small airports? It's only commercial airports. And this is what we're doing to honor our veterans.
The senator speaks with great passion. I'm certain she knows of what she states. For what purpose does the senator from the 43rd rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that even while we're in this room right now, veterans are protecting us and they deserve 2 parking spaces at commercial airports?
The senator would certainly know. On the motion, the yeas are 53, the nays are 2, and the Senate has agreed to the House substitute to Senate Bill 103. The chair would like to recognize the majority leader.
Mr. President, I move that the Senate stand adjourned. Sine die.
The majority leader has moved that the Senate stand adjourned, sine die. All those in favor signify by saying aye. Opposed, no. The ayes clearly have it, and the Senate stands adjourned, sine die. Great job. Very nice.